Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and the prosperity of our nation. Amen.
Oath or affirmation announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Paula Gopee-Scoon, Senator the Honorable Dennis Moses, Senator Wade Mark, and Senator Dr. Daneshwar Mahabir, all of whom are out of the country. Honorable Senators, I have received the following correspondence from His Excellency the President Anthony Thomas Aquinas Carmona, ORTTSC. The Constitution of the Republic of Trinidad and Tobago by His Excellency Anthony Thomas Aquinas Carmona, ORTTSC, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Ndale Young. Whereas Senator the Honorable Paula Gopee-Scoon is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate, with effect from the 27th of February 2018, and continuing during the absence from Trinidad and Tobago of the said Senator Paula Gopee-Scoon. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's, this 26th day of February 2018. To Ms. Alicia Romano. Whereas Senator the Honorable Dennis Moses is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Alicia Romano, to be temporarily a member of the Senate with effect from the 27th of February 2018, and continuing during the absence from Trinidad and Tobago of the said Senator Dennis Moses. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's, this 26th day of February 2018. To Mr. Sean Sobers. Whereas Senator Wade Mark is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Sean Sobers, to be temporarily a member of the Senate with effect from the 27th of February 2018 and continuing during the absence of Senator Wade Mark. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 26th day of February 2018. To Ms. Stacey Cummings. Whereas Senator Daneshwar Mahabir is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Stacey Cummings, to be temporarily a member of the Senate with effect from the 27th of February 2018 and continuing during the absence from Trinidad and Tobago of the said Senator Daneshwar Mahabir. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 26th day of February 2018. Honorable Senators, Senators are required to take the oath.
I, Ndala Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear truth, faith, and allegiance to Trinidad and Tobago, and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Alicia Romano, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Sean Sobers, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility to the people of Trinidad and Tobago upon which I am about to enter.
I, Stacey Cummings, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the National Institute of Higher Education, Research, Science and Technology for the year ended December 31st, 2010. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Superior Regional Corporation for the year ended September 30, 2012. And the report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Police Complaints Authority for the year ended September 30, 2015 and September 30, 2016. Thank you, Madam President.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Health. The ministerial response of the Ministry of Health to the fourth report of the Joint Select Committee on Social Services and Public Administration, third session, 2017-2018, 11 Parliament, on an inquiry into the prevalence of sexually transmitted disease, STDs, amongst school students and into general services administered to treat STDs in Trinidad and Tobago.
Reports from committees, urgent questions.
Senator Ramkissoon.
Thank you, Madam President. To the Minister of Works and Transport. In light of the recent protest action by residents of Lengua Road, Indian Walk, to highlight the poor state of infrastructure in their community, what immediate action is being taken by the Ministry to alleviate the plight of these residents?
Minister of Works and Transport, you have 2 minutes.
Yeah, thank you, Madam Vice President. Madam Vice President, Madam President, it's no secret that the constituency of Maruga, there are some challenges in terms of the soil that is in that area. Unfortunately, at the Lengua Road, there was a WASA pipeline that was ruptured, and that caused severe damage to the base of that landslip. Unfortunately, the landslip gave way, and at this time, the ministry is initiating temporary action where we will be putting in a base coat and hot mix. And the long-term plan is to have it included in our bridges and landslip program for a more permanent fixture. Thank you.
Soon.
Thank you, Honourable Minister, for your response. With respect to the same issue, has this action been communicated to residents and any assurances given?
Minister.
Thank you. Madam President, immediately upon the report, the ministry would have dispatched a team to the area to investigate, and my information is that as of today, they will be looking at bringing in remedial work.
Next question. Oh, sorry, Senator Ramkissoon, one more? Yes.
Thank you, Madam President. With respect to the same issue again, there's a particular resident house that was damaged during the process. Has consideration been given to that resident at all in this matter?
Madam President, I'm happy to inform the Honourable House that the resident have moved out yesterday with the help of the HDC and the Member of Parliament, and now work can go on. Because that was one of the challenges in trying to bring repairs yesterday. We had to ensure that the resident was had vacated his house.
Next question, Senator Richards.
Thank you, Madam. Thank you, Madam President. Good afternoon, everyone. To the Minister of Social Development and Family Services, what immediate assistance will be given to the 5 families from Bamboo Village, Cedros, who were evacuated yesterday after losing their homes to severe coastal erosion?
Leader of Government Business.
Thank you very much, Madam President. Madam President, the Ministry of Social Development and Family Services is one of the second responders responsible for providing support to needy families and individuals in crisis and emergency situations. Obviously, what happened in Cedros yesterday is one such incident. Facilities that are available include household items up to $10,000, clothing grant $1,000 per person, school supplies $1,000 for child attending secondary, $700 primary, house repairs up to the value of $20,000, house rental grant $25,000 per month for initial period of 3 months, which could be $2,500 per month for an initial period of 3 months. And if alternate accommodation is required, they may be extended a further 3 months depending on the needs of the situation, and obviously counseling support. Accordingly, affected families will be visited by officers of the Ministry of Social Development and Family Services between today and tomorrow. But more importantly, Madam President, at 7 a.m. this morning, social workers attached to the Social and Community Relations Department of the HDC were dispatched to Cedros to interview and conduct an assessment of the affected families. 8 families presented themselves as persons in need of emergency housing assistance. They were interviewed and assessments are being conducted as we speak. Vacant housing units have been identified in the Point Fortin area, which is the closest HDC development to Cedros, and very likely the affected families will be provided with temporary solution there.
Senator Richards.
Yep. Thank you, Minister, for your comprehensive response. Has consideration been given, Minister, in light of this relocation, though it may be temporary, to the children who are involved in terms of giving them transportation facilities so that their school service is not disrupted?
Minister.
I'm almost sure all these factors will be included, bearing in mind Cedros is in the southwestern extremities of the island, and the closest town to Cedros with HDC settlement is Point Fortin, but Cedros is part of the Point Fortin constituency, so I'm almost sure that temporary arrangement will be made for them to transport them, because if they are primary school students, I'm almost certain they are attending schools in Cedros.
Senator Richards, next question.
Thank you, Madam President. To the Minister of Works and Transport, what immediate measures are being taken to repair the infrastructure of Bamboo Village Cedros in the aftermath of yesterday's incident of severe coastal erosion in that area?
Minister of Works and Transport.
Thank you, Madam President. Madam President, the Ministry of Works and Transport currently has a team of specialists on site conducting an assessment to identify the prevailing cause of severe coastal erosion which occurred in Cedros. Based on the preliminary report of homes being eroded, the Ministry of Works and Transport, in its evaluation, seeks to identify whether other properties are at risk and the root cause of the cliff failure. At the moment, it will be premature to provide any recommendation until this assessment is completed. On completion of the assessment, the Ministry of Works and Transport will prepare a report outlining the recommendations to be implemented, bearing in mind that the way forward may include the collaboration with other ministries and agencies. I thank you.
Senator Richards.
Thank you again, Madam President. Minister, can you indicate, given the fact that these 5 homes were the ones who were destroyed due to the erosion, but there may be other homes in precarious circumstances and other lives in possible danger, the kind of timeline indicated in assessing the possibility of danger for these other homes in the immediate vicinity? Sorry.
Minister.
Madam President, as I said, part of the program of work today is to identify other properties at risk. As we speak, the team from the Coastal Department are on site with drones and technology to complete this survey by today. So I expect this report by tomorrow. Thank you.
Senator Richards.
Thank you again, Madam President. My final question. My information, it may be erroneous, it's gotten through the media, so excuse me for this, but there are other families who have grave concerns that their properties are in immediate danger, and some sort of assurance where they are concerned in terms of what the possibilities are.
Senator Richards, I won't allow that. It's kind of been covered by what the minister said before. Senator Amin.
Thank you, Madam President. to the Minister of Agriculture, Land and Fisheries. In light of reports of dead fish and bird carcasses washing up on the shores of Carrot Beach, Labrie, yesterday, what steps are being taken by the Ministry to warn residents of the dangers of consuming the fish?
Minister of Agriculture, Land and Fisheries, you have 2 minutes.
Madam President, thank you. I was very surprised at the question, but Madam President, the Ministry has taken no steps to deal with this issue simply because, Madam President, it is not normal for residents, particularly those in fishing communities, to consume decomposing fish found on the shore.
Madam President, the question is not about them consuming the dead fish, but consuming fish in general. So I don't know if the question is with regards to a warning to ensure that people are well informed and well educated about the dangers of the fish that are still alive, but may somehow be affected by whatever is affecting the fishes that are dying.
Minister.
Madam President, purely in the public interest, because the question directs me to dead fish, but purely in the public interest. Nothing that happened yesterday at Carrot Beach, Labrie, raises a concern in my mind and the Ministry in relation to the consumption of fish. Thank you.
Questions on notice, question for oral answer.
Leader of Government Business.
Madam President, the government is pleased to announce that it is in a position to answer all 4 questions, but I have been informed that because of Senator Wade Mark's absence, the opposition would not be proposing on this sitting questions number 37 and question number 51. So we will answer the other 2.
Senator Amin.
Question 15 to the Minister of Education.
Minister of Education.
Thank you very much, Madam President. No laptops were acquired as of September 30th, 2017. And as a result, the answers to parts B to E of the question are not applicable. Thank you.
Next question, Senator Amin.
Question number 54 to the Minister of Education.
Minister of Education.
Madam President, let me reiterate that there is no upsurge of violence and indiscipline at our nation's schools. At the Ministry of Education, there is an established standard procedure for treating with incidents of violence and indiscipline which may occur, as in the case of St. Anthony's College or any of our schools in the near or foreseeable future. The procedure involves 1. Submission of written reports from students who are victims, perpetrators, and witnesses. These reports must be signed by their respective parents or guardians. 2. Parent conference with principal, dean, students, and members of the Student Support Services Division. 3. Student suspension for 7 days with a request for extended suspension where appropriate. 4. Student referral to the Student Support Services Division, which includes referral to the Learning Enhancement Center if necessary. 5. Address to the student body by the principal at morning assembly, emphasizing zero tolerance to such behavior. And 5. Implementation of individual, group, or whole school programs as may be recommended by the Student Support Services Division. Thank you.
Senator Obika.
Thank you, Madam President. Through you, I would like to ask the Minister, because the Minister, we thank the Minister for the general thing, but specifically in St. Anthony's College, which of these measures were implemented?
Minister of Education.
Thank you very much, Madam President. When the incident occurred at St. Anthony's, the principal did a thorough investigation, and as a result of the investigation, some of the students were suspended. And that is the position as it stands. Thank you.
Senator Obika.
Thank you, Madam President. Regarding the, because these children are still, they're not adults, even persons who may be bullies, there may be, what would be the corrective measures taken beyond suspension to prevent it from recurring when they re-enter the school system?
Minister of Education.
Madam President, the principal, in his or her discretion, will determine the severity of the incident. In this case, the principal determined that the person should have been suspended for a maximum of 7 days, and that is what happened.
Senator Amin.
Another supplemental. Given the measures outlined by the Minister with regards to Dean's Social Support Services Division, etc., is the Ministry of Education adequately staffed with social support services and other social and psychological support services staff to deal with the problems of violence and bullying that are in the schools?
Minister of Education.
Madam President, in the other place I answered that question. I can reiterate my answer. Yes, we are convinced that the Student Support Services Division of the Ministry of Education is adequately staffed. Thank you.
Senator Hussain.
Thank you, Madam President. Can the Minister indicate whether or not the Ministry has taken any steps in order to devise a cybercrime bullying policy with regards to schools?
I won't allow that question.
Do you have another supplemental on this? Yes. My final supplemental, what mechanisms are in place to measure the effectiveness of the measures that you outlined earlier, the effectiveness of the way to treat it?
Minister of Education.
Again, thank you very much, Madam President. I mentioned just now that in some cases, we will have a case conference involving the parents, the dean, the principal, and the student. At this conference, the entire situation is examined carefully, and as a result of discussions involving all parties, a final decision is taken. In this case, because of at the conference, it was decided that the 7-day suspension was sufficient, and there was no need for any further action.
Okay. Yeah.
Motions relating to the business or sitting of the Senate and moved by a minister.
Leader of Government Business.
Madam President, in accordance with Standing Order 31.5, I beg to move that the Senate consider government business instead of private members' business.
Honorable Senators, the question is that the Senate consider government business instead of private members' business. Those in favor say aye. Aye. Those against say no. The ayes have it. The Senate will consider government business instead of private members' business.
Public business, government business, bill second reading.
Honorable Senators, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Tuesday, the 20th of February, 2018, will be resumed. A bill entitled An Act to Amend the Mutual Assistance in Criminal Matters Act, the Proceeds of Crime Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Customs Act, and the Exchange Control Act. Those who spoke on this bill already are set out as follows. The Honorable Faris Alwari, MP, Attorney General, Senator Wade Mark, Senator Dr. Danishwar Mahabir, Senator the Honorable Alison West, Minister in the Ministry of Finance, Senator Khadija Amin, Senator David Small, Senator Dr. Lester Henry, Senator Saddam Hussein, Senator Torel Shrikissoon, Senator the Honorable Paula Gopi Schoon, Minister of Trade and Industry. Senator Sobers.
Good afternoon, Madam President and other honorable members of this House. I would definitely like to thank Madam President for giving me the opportunity to today contribute to this bill, an omnibus type of bill that has been entitled the Miscellaneous Provisions, Mutual Assistance in Criminal Matters, Proceeds of Crime, Financial Intelligence Unit of Trinidad and Tobago Customs and Exchange Control Bill 2017. A lot has been said already on this particular bill, but there are still things that I believe the country should be made aware, and it is my intention today to touch on some of the things that have been spoken on before, elaborate a bit more on them, and raise new issues that have not been spoken of before. The intention of the bill before us, as proffered by the government, is one, to bring forward legislation in hopefully a meaningful way that would address some deficiencies as it relates to the current pieces of legislation that we have. In particular, these pieces of legislation attempt to provide some level of enforcement, meaningful enforcement, to certain existing agencies that treat with the bills before us today, the legislation before us today. In particular, I considered the Financial Intelligence Unit and the units that work alongside those units, which would be the Financial Intelligence Bureau or branch, and also the Customs and Excise Unit. And those agencies have been operating for quite some time without the level of efficacy and efficiency that one would hope. And I can understand and appreciate where the government is going in trying to provide those agencies with this level of enforcement. Many persons from the public domain constantly talk about bulldog agencies being alive. But these bulldog agencies do not have the level of teeth or enforcement that is required to do their jobs effectively. And I can understand and appreciate the government's aim to try to marry the two, to move forward and provide these agencies with the level of enforcement required. But there's still a pertinent ingredient missing in that marriage. You have the agencies existing, the bulldogs roaming, and now you try to provide the teeth, the level of enforcement required. But there's still a particular limb missing to ensure the effectiveness of the legislation that you're trying to put on the books today, which is a brain. These agencies lack that type of skill, that type of technical capability and infrastructure to ensure what the government's intention is to be properly carried out, meted out at all levels of society. And it is my hope today, through my contribution, that I can highlight some of these deficiencies in the agencies and give solutions as to how maybe the government could get it right this time around. So I will quickly jump into the bill itself. The first clause deals with the Mutual Assistance in Criminal Matters Act, Chapter 1124. Well, not the first clause, the clause 2 of the bill. Clause 2 of the bill proposes an amendment to this act. Clause 2 states that the bill proposes to remove one of the many powers granted to the central authority by deleting Section 22(2)K of the Act, which empowers the authority to refuse a request that relates to a criminal offense under the tax laws of a Commonwealth country. Now, many senators would have spoken on this issue, and I would like to touch in particular in terms of what Senator Hussain would have said about this particular clause. The clause, as it stands on the books today, allows the central authority, which is an arm of the Attorney General's office, to do certain things, to accede to certain requests, and to not accede to those requests. The clause actually states that The requests that relates to criminal offences under the tax laws of a Commonwealth country, save that the assistance may be granted if the offence is committed by way of an intentionally incorrect statement, whether oral or written, or by way of an intentional failure to declare income derived from any other offence covered by the Inter-American Convention on Mutual Assistance in Criminal Matters. That provision allows the central authority to say, yes, we will accede to the request based upon these criteria. We also retain our sovereignty to say no when we believe the request may be flippant or frivolous or does not account for what is placed within the criteria. What the government is trying to do is to remove that ability for the central authority to say, no, we are not going to accede to that request. And I find to interfere with a clause like that, to interfere and amend it like that, is interfering with our nation's sovereignty as it pertains to the central authority's ability to say no. It is not sufficient that we as a parliament or as a republic should just accede to any request made by any agency, be it FATF or whatever. We must retain some level of sovereignty. And for us to continue to slavishly operate based upon requirements given to us, not retaining any element of sovereignty, in my opinion, is absurd. I would like to see in this particular clause that the section is amended, wherein it would reflect legislation to maintain some level of scrutiny or criteria in terms of testing the request made by the organization or the entity or the state, whosoever makes the request, so as to guard against any level of mischief and malfeasance that may arise from the country giving the request. That way we ensure that we don't flippantly give away our sovereignty. Everywhere else in the world, people jealously guard their sovereignty. We here, we are willing to give it away. That cannot stand. I move on now, because there's a lot to be said, on the Proceeds of Crime Act, Chapter 1127. Now, from time to time, once given the opportunity, and I am here, I constantly like to say that the opposition, we operate in a particular manner. We don't just come here to oppose for opposing's sake, as many of you may not believe, but that is our intention, not to come here and oppose for opposing's sake. And when the government brings forth legislation that can get it right, I am one who would call and affirmatively address the situation. And I think in terms of the amendment to this particular clause, clause 3, which simplistically attempts to allow for a hybrid situation with respect to money laundering offenses, allowing for persons to be able to access the summary courts, I think, in my opinion, it is a step in the right direction. And I say that based upon the fact that what would the end result of that situation would allow for persons will, one, firstly get an option to choose whether they would like their matters to go to indictment and possibly spend quite some time in the judicial system before it actually reaches a court in the High Court, or they can actually deal with the matter summarily and have it disposed of either by pleading guilty and having it dealt with there and then, or engaging in a trial at the magistrate's court and cut down on the length of time that the matter will take on indictment, right? And that system, in terms of allowing persons a choice, has been echoed by one of our celebrated judges in the Puny Court, by Justice Lucky. Madam President, if you would allow me, an article in the Trinidad and Tobago Newsday, the 26th of this instant month, is entitled Estonian Sentenced to Time Served. Within this article, a High Court judge has offered several recommendations for greater efficiency in the criminal justice system. She speaks in this article about an individual who would have been sentenced to 5 years. He spent actually 5 years and 22 days in prison on a conspiracy trafficking cocaine charge. And he wanted to plead guilty to the offense in January of 2013, but was unable to so do because that particular offense was indictable only. So the court was not able to treat with his situation. He His case was heard summarily, and he had to spend 2 years, 8 months in prison, and it took an additional 8 months before he could have been sent back to Estonia. In his case, he was charged with conspiracy since he admitted he did not swallow any of the pellets and also insisted the police in their investigation. While not ascribing blame to any department, Lucky said something had to be done to fix the blockage in the criminal justice system. It is my belief that in terms of making this a hybrid situation, allowing persons to exercise a choice as to where they want their matters to be heard is alleviating some form of blockage in the system. Justice Lucky further went on to say that a guilty plea court should have been, is also a suggestion with respect to dealing with cases in an attempt to fast-track these issues. And that would definitely allow then for persons or agencies who would like to come to speak about statistics as it pertains to these acts, that you won't be able to come to the floor and talk about persons just only being charged. You'd be able to further that and say that there have been persons who've been convicted, either because they pled guilty at the magistrate's court because now they have that option, or they chose to deal with the matter at the magistrate's court and were found guilty. So you will have recorded convictions showing that the law itself has been tried, tested, and proven to be true. It would also definitely act as a deterrent for persons who, continue to breach the law. They would have the ability now to have the situation dealt with at the magistrate's court. Now, in terms of considering the solution envisaged in giving an option at the magistrate's court, there's also a consideration of a drawback. The drawback relates then to a balance between the ability to choose and then the ability to actually make the choice. I, as a quasi-criminal attorney, cannot see for myself, giving any advice to any client about pleading guilty in a magistrate's court or engaging in a magistrate's court with respect to a situation like this, where the fine on summary conviction is $25 million and imprisonment for 15 years. If you want to encourage persons to avail themselves of the option available in the magistrate's court, that fine is, as it is right now, or is being proposed, is too harsh. It must be reduced to consider, or to at least entice persons to consider that choice of being tried in the magistrate's court. It is too harsh as it is right now. I would also want to suggest to the government that they look at possibly having certain individuals, professionals in that field, to treat with cases of this nature if they engage in magistrate's court. Because I dare say that there may be a level of very minute deficiency in that area with respect to judicial officers being able to hear these matters in the magistrate's court. I move on. The next point brings me on to the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201. That act deals with some changes to the Financial Intelligence Unit. Now, I may have missed it in terms of listening to the contributions because I was not here on the last occasion. But I know that there may be, at least for the benefit of the viewing public, persons may not truly understand what the Financial Intelligence Unit is. And I juxtapose its operations to that of the Police Complaints Authority. The Financial Intelligence Unit is a unit engaged to take reports from financial institutions such as banks and others, and then investigate those reports. If there's any level of criminality, they would then forward those reports to the agencies that can take action, such as the Financial Intelligence Bureau, the Anti-Corruption Bureau, the Fraud Squad, all arms of the Trinidad and Tobago Police Service. And then they would then pass those investigations onto the DPP's office for charges to be laid if necessary. Now, in terms of the FIU and their relationship with the FIB, this is a clear example of where you have the agencies operating and existing, and now you're providing greater level of enforcement, teeth for them, but there's a missing limb of that technical capability to do the will that Parliament has envisaged in this House, to carry out the will of Parliament and effect the legislation to bring about convictions. And I say that because if Madam President would allow me, in the Trinidad and Tobago News again, February 26th of the 26th of this instant month, it is entitled 27 Charged for Money Laundering. This is a release from the Financial Intelligence Bureau. Since its establishment in 2011, the Financial Intelligence Branch has charged 27 people for money laundering to the value of $14 million, over US $40,000 and more than 1,000 Canadian dollars. In 7 years, 27 charges only, no convictions. 7 years. The FIB plays a pivotal role in the investigation, detection, and prosecution of money laundering and terrorist financing, as well as the restraining and subsequent forfeiture of assets, cash seizures, and investigations relating to the Proceeds of Crime Act 2015. This is what was said by Inspector Avinash Singh of the FIB. Not you, Honorable Senator. Right? But throughout the entire excerpt here, throughout the entire article, he breaks down the charges, the amount of money, the different investigations. But nowhere in the body of this article does he speak to convictions. He goes on to say, he added that there are 45 investigations being conducted by the FIB, and several of these cases surround allegations of terrorist financing and money laundering. But not one hint or talk or mention of a conviction in 7 years. That speaks to capability or a lack thereof. And there's a reason for that, if Madam President would allow me. And this is an article from the Trinidad and Tobago Express from the 19th of February in 2014. And I bring up this article because what is contained here is unfortunately reasonable for us to understand where we are currently, right now, as one considers the FIB and its interactions with the FIU and trying to bring about convictions based upon this legislation. The investigation of white-collar crime in Trinidad and Tobago is non-existent. This coming from an attorney and anti-money laundering expert, David West, in this matter. Right? He says that at that point in time, we are still deficient from the third round evaluation by the Financial Action Task Force, which is the FATF, and going into the fourth round of evaluation with no legislation for new requirements like weapons of mass destruction and tax evasion. Come 2014, after we are evaluated, we will see exactly where we stand, which I can say from now does not look like a pretty picture. The picture worsens. When suspicious transactions are reported to the FIU, they in turn hand it over to 4 investigative bodies: the Financial Intelligence Bureau of the Trinidad and Tobago Police Service, the Board of Inland Revenue, Customs, or Immigration. After their investigations, they in turn hand over those files to the Director of Public Prosecution. He goes on to say, but the investigative capacity of the FIB is diminished by a lack of expertise and training. The FIB was set up ad hoc because we had to comply with FATF guidelines, and they staffed the department with people they seconded and have a few years left on their contracts. They aren't interested in money laundering. Then they send these people away for training 2 weeks in Jamaica and then expect them to be qualified to investigate money laundering. That cannot work. And the US and British do training sessions, but under their laws, not ours. So it is difficult to reconcile the differences. They are at a loss with no proper guidance. This is the agency tasked to investigate documentation forwarded to it from the FIU. So if this particular agency, this bulldog, is not equipped to treat with this high level of and technical investigation, that is the exact same reason why after 7 years we only have 27 charges and no convictions. And to come to the House with legislation to deal with sanctions and to deal with providing this teeth to these agencies and not dealing with infrastructural capabilities, technical capabilities, stacking these agencies with skilled persons who've gone upon training within our own jurisdiction to deal with our own laws. You're not going to have an issue where here, after we pass this bill, if it is passed, that you're going to have convictions being recorded magically. Because you're dealing with the same khaki pants, same persons, without the level of capability and skill required to properly effect the legislation. That has to change. And I have not heard anything from the other side talking about what infrastructural overhauls, if any at all, have been done at these agencies. I wanted to also, so more needs to be done. More needs to be done with these agencies. I was a bit confused as it pertained to Section 18G of this very said bill, wherein there's a clause that sets out to deal with respect to the issuance of a warrant and whatnot. In the current legislation, it deals with a person of the rank of sergeant and of above a sergeant's rank, which is an inspector, and that person being able to execute a warrant and whatnot. I am a bit confused as it pertains to the wording here, whether or not that situation has now been changed and it allows just for a police constable to execute the warrant. If that is the case, I would want to say then that some inspection needs to be done as it pertains to how the warrant is obtained. I am not comfortable being a criminal practitioner knowing how warrants are obtained. Police officers usually, they have the ability to go to a magistrate or to a justice of the peace. In most, if not all instances, they go to the GP because they are on first-name basis with the GP. I am not comfortable. I think the law needs to be changed, or there should be some section to deal with how the warrants are procured, and the warrant should definitely come from a judicial officer, either a magistrate or a judge. That would definitely make me feel much more comfortable. Moving on. So I now go to the Customs Act. The Customs Act, Chapter 7801. And I will start off with Section 23 of the Customs Act. Section 23 of the Customs Act deals with the value of goods imported. Section 23(2)(a) states that the comptroller may, within 1 year from the date of entry of imported goods, adjust the value accepted by an officer at the date of entry where he discovers that the value accepted by the officer was incorrect based on new information concerning the goods or for any other reason. Clause 5 of the bill proposes to amend this section so that it empowers the Comptroller of Customs to adjust the value of goods accepted by an officer within 6 years from the date of entry of the goods via notice in writing to the importer. From 1 year to 6 years. Why are we going back? Why are we regressing? Why are we allowing customs officers the ability, no offense to customs officers, to now have that luxury to operate in a laissez-faire manner in terms of treating with back taxes? Why are we allowing a guillotine to be constantly hung over the necks of the business community, wherein they submit invoices, they pay their taxes, and now they have to wait for 6 years to see whether or not this comptroller or this customs officer is going to approach them concerning back taxes and interest to be paid on the taxes? As a responsible parliament and a responsible government, we should not be moving regressively, but actually progressively. I know for a fact when persons come into this country and you come into the airport and the customs officer tells you, well, open up that suitcase, let me see what's inside. And you take out 2 iPhones, iPhone 10 or 12 or wherever they reach right now. And he inquires of you, what's the price of that? What you paid for that? You tell him a bold-faced lie. I paid 400 US for it. The customs officer at the desk there is going to tell you, no problem, hold on. He's going to go into the back room. He's going to Google the iPhone 10 or 12 that you produced to him with the same specifications. Know that you're being untruthful in terms of your declaration. Come back out, face you with the untruth and tell you need to pay the correct duties on that. If he can do that in 5 minutes, why are we now saying that we're going to give these persons 6 years to do the very same thing? It happens on a bigger level at the port, I agree. But 6 years is too long. And I would have spoken to members of the custom brokerage community. I've spoken to importers. And they tell me this thing is going to encourage bribery. It's going to encourage racketeering. You're going to have a situation where you submit your documents, you pay your duties and your taxes, and you are home relaxing. You don't have this documentation stacked up, prepared and waiting. And 5.5 years later, these customs officers are going to come back and tell you, you owe this to the government. That cannot be right. We don't know what could even possibly happen to the documentation. There's a possibility that fire could have ravaged the person's home. Flood could have destroyed the documentation. What position does that place them in? More needs to be done. More needs to be done. I would have liked to see, instead of a change from 1 year, we increase the infrastructure at the Customs Authority, give them the requisite skills that they require to move them from having this position of 6 years or even 1 year to 6 months. And that is a step in the right direction, not giving them this time of 6 years. And the reason being advanced is because we want to get everybody on the same playing field as income persons from BRI and whatnot. That is insufficient. It is insufficient, rather. Clause 5 of the bill also sets to further amend Section 23 by the addition of a new subsection after subsection 2A. The new subsection 2B will give the Comptroller of Customs the power to refuse entry or delivery of subsequent shipments of an importer where an adjustment is made to the value of his goods and he has not paid the adjustment and fails to commence proceedings before the appeal board within 6 months from the date of notification. I opine that there are 3 things wrong with that position. The first and foremost is that particular position, in my opinion, is against the principles of natural justice. It cannot be that I am the Comptroller of Accounts and levying a charge against you as it pertains to fraudulent tendering of documents or an improper amount being tendered. And I come at you now to require further back taxes from you. The Comptroller of Customs had 6 years to get this done. You have to do it within 6 months if you want to lodge an appeal. You simply cannot get it done. It cannot be that the judge also now, dealing with the jury aspect of things, is not giving you the opportunity to have your situation ventilated. Before the issues are being ventilated, he puts a sanction on you wherein you cannot move forward. Your goods are left outside of the port. You cannot import these goods in before the situation has been properly ventilated. That goes against the principles of natural justice. Both sides must be able to be heard and a decision arrived at. Not one side is being advanced, the other side is trying to get their house in order, and a decision has already been made in terms of your guilt. That has to change. Secondly, it removes the ability of working capital for the individual to fight the appeal. If your business is largely related to goods being imported into the country, for you to restock your business and have your sales going, you need money in any event to deal with the appeal, to treat with this new sanction that has been levied against you. If you cannot import your goods, you cannot pay the lawyer or you can't pay whoever else to treat with your appeal. So you have been cut off. You are now being placed under duress now because you have no income coming in to treat with this sanction that has been placed against you. Further, it renders the enforcement procedure by the very said customs authority otiose. If I have leveled a sanction against you to pay $500,000 or $600,000 in back taxes, and in order for you to pay those back taxes, you have to have your goods coming in to have them stock your business places and have sales going. And those goods have been stopped from coming in. How are you now, even if you would like to pay these back taxes, going to pay them? Because you no longer have your working capital. It's counterproductive. The same level of enforcement that they're trying to implement against you, that you would like to work with them on, you can't treat it because you don't have the working capital. The government needs to look at that holistically and try to deliver a better option in terms of implementing the sanction. At section 45(1), it goes on to say, of the Customs Act, lists the goods which are prohibited from being imported. Arms and ammunition, except with the written permission of the Commissioner of Police, are prohibited under section 45(1)(c). This subsection will now be deleted by clause 5 of the bill and substituted with a more detailed provision to include firearms, ammunition, bulletproof vests, and firearm accessories, inclusive of lasers, lights, holsters, scopes, and tools for the purposes of maintaining a firearm. Now, so this particular clause intends to make it illegal for a person to import lasers, lights, holsters, scopes, and tools for the purposes of maintaining a firearm, unless one has an FUL or one gets permission from the Commissioner of Police. Right. One would naturally think then, if it is illegal to import these items, it would also then naturally be illegal to have them in your possession, unless you are the holder of an FUL or unless you have received permission from the Commissioner of Police. Currently, under the Firearms Act, the definition of a firearm means any lethal barreled weapon from which ammunition can be discharged or any prohibited weapon, and includes any component, part of any such weapon, and any accessory to any such weapon designed or adapted to diminish the noise or flash caused by firing the weapon, but does not include any air rifle, air gun, or air pistol of a type prescribed by the order made by the President and a caliber so prescribed. Nowhere within that definition of a firearm do we see lasers, lights, holsters, scopes. And further down in section 6(1), it is illegal for a person to have in their possession a firearm if you don't have an FUL or an FUEC. So if we are making it illegal for lasers, lights, holsters, scopes, and tools to be imported without the requisite permission, and it should also be illegal for a person to hold these things in their possession without having the requisite permission or the FUL, then the Firearms Act, as it pertains to the definition of a firearm, should be amended to include lasers, lights, holsters, scopes, and tools. Because as it is right now, it is not in the Act. It is not in the Act. And you would not want to be in an embarrassing position where you are saying, hey, you cannot import these things because a law has now been passed saying that you can't, but persons are in possession because the law doesn't say that you cannot be in possession of it. It does not form part of a firearm. The Act needs to be amended as well, too. Right. Lastly, as it pertains to the Exchange Control Act, Chapter 7950. As a matter of fact, the Exchange Control Import and Export Order 1993 as well. I listened to Senator Mahabir as it pertained to how he viewed the amounts, the disparity in the amounts with respect to the instruments that persons would have been allowed to carry and get any requisite permission. And I largely agree in principle in terms that the U.S. allows then for persons to have and not declare up to $10,000 US.
Senator Sobers, you have 5 more minutes.
Thank you, Madam President. And in principle, I believe then that the figures should be amended to reflect that position and not be kept as it is right now in its current form or is being proposed by virtue of the amendments. In closing, I think that there are a lot of gaps in terms of this bill that has come to the floor. fresh eyes by other senators may also illuminate these other gaps. And I do encourage persons to look at this thing with an open mind and consider that it should have been sent and can still be sent to a joint select committee for these issues to be properly fleshed out and ventilated, so we don't find ourselves in an embarrassing position having passed this piece of legislation in this House. I thank you, Honourable Senators.
Senator Ramkissoon.
Thank you, Madam President. Before starting, I have to commend the Attorney General on the piloting of this bill and the manner in which it was done. It was truly an excellent piloting in which he gave us not only the clause by clause, but a reasoning behind why we were seeking to amend these pieces of clauses for the different bills at this time. And I thought that was very commendable because it is not a small bill. It is a large bill because we are looking at 5 different acts at this present time in one omnibus bill. And it is very helpful for any senator sitting here to know what is the reasoning or what is the rationale or what is the purpose or why we as a country needs to go in this direction. Madam President, also at the last sitting when we started this debate on this omnibus bill, the Minister of Trade and Industry, during her contribution, highlighted our country's reputation and how it is important for our revenue streams, sustainability, our economy, and also our diversification. And I was very proud to learn that Trinidad and Tobago has improved in its ranking in the Corruption Perception Index, moving from 101 in 2016 and to 77 in 2017. So commendable to the present administration for getting us there. I do think it's something we should all be proud of. We always speak about it during our budget deliberations that this is where we want to see ourselves improving, and we have improved, and I had to acknowledge it before I dive into this bill before us. So, Madam President, I have highlighted that we are looking at 5 pieces of legislation, and we have outlined them, and I'm going to attempt to do my best in bringing across the points within the time that is given. I do believe it's an ambitious task because there's so many different aspects that can be looked at when we're looking at 5 different acts in one sitting or one debate. So, Madam President, there is a little tickle I have when we look at bills, when we're not looking at the entirety, but we're looking at clauses. And sometimes we, as a parliament, we tend to miss things because, obviously, because of time constraints, we don't look at it every single clause, and we just try to see what's going to best affect us now, so we amend as such, which is good, but sometimes we miss something that is very, very important that also impacts directly to the amendments being made presently. So, for example, if we're amending the Proceeds of Crime Act, we'll have 2018 on the front page, and we would expect that 2018 it was looked at. And when I was looking at the Proceeds of Crime, I saw that in Clause 56B, we spoke about a joint committee of Parliament to handle the proceeds of crime, which we don't presently have. So again, we will be missing this in 2018, or maybe not addressing it in 2018, even though it's before us presently. So that's my only issue when we look at select clauses and not the proceeds of crime as a whole. So, Madam President, the speaker before me, Senator Sobers, did touch a lot about proceeds of crime and in terms of the money laundering. But I would like to give my points from a different angle. Firstly, we learned during the piloting that we're implementing these fines, so not additional fines, because existing fines is 20 million, and the additional would be for indictable offenses, we're doubling it to 50 million. And that is to put a hold or kind of sober Trinidad and Tobago into being reluctant to turn to a life of crime or turn to money laundering as a sort of criminal offense. And I thought it was very interesting to see that we went to clause 53.1, which states a person guilty of offense under sections 43, 44, 45, and 46. But I did not hear any other senator go to that section, which is section 43, 44, 45, and 46, which is what we are amending. And if you look at it in 42, which is part 2 under money laundering, it says an offense committed under sections 43 to 46 shall be known as a money laundering offense, and the term money laundering shall be construed accordingly. Part 2, the offense of money laundering is an indictable offense. But we are now 2 pages after, in clause 53, a person guilty of an offense under sections 43, 44, 45, and 46 is liable on conviction and on summary conviction to a fine of $25 million and imprisonment for 15 years, and on conviction on indictment to a fine of $50 million and to imprisonment of 30 years. So I said a lot of words there. What I'm trying to say is 2 pages before, in clause 42, 43, 44, 45, we are saying it is an indictable offense. But yet, in another clause, we are giving you a fine for summary conviction and indictment. Why? We did not amend it before, but yet we're giving you fines of it. So I didn't find it was very consistent. And then we're going to talk about, Senator Sobers brought up the point of, in the present or existing legislation, there is the fine of $25 million, which he found was high. And I have to say I agree with him. Because when I initially read it, $25 million, I did not believe this was for new offenders. And I can prove why I'm making that statement. Because we don't make assumptions or feeling thoughts here. We try to look at our country's history, and we try to see what guided this figure, what guided this fine, and why we want this as our present legislation or part of how we're going to change the paradigm of money laundering offenses in Trinidad and Tobago. So let me explain my hypothesis. In the Guardian article, Wednesday, June 28, 2017, an accountant on money laundering charges, there was an accountant, Mr. Cox, was granted $600,000 bail for fraud charges on money laundering. He was charged 18 of the 21 charges he got for bail. But what was his offense? He had made false checks of $30,000 and in total sum of $90,000. So he had a money laundering charge alleged that he disposed of various sums of money totaling $30,600 TT. And then I'm thinking we want to charge Mr. Cox $25 million for this money laundering offense of $30,600. I'm not exactly sure what message we're trying to send. And maybe, is this why we have no charged persons? Because we have 27 charged, but we have not convicted. Is this why no one is convicted? Because these fines are very unfair and very high. And we know that somebody who has a money laundering offense of $30,000 cannot pay a fine of $25 million, and he's just going to go to prison for 15 years. Is this why we have not convicted any of these persons? And this, for me, was not addressing any of our issues that we're trying to change by changing or amending these present bills before us. Senator Dan, in his contribution, highlighted an issue with the Summary Offences Act, Clause 42, where all cases punishable under this act, which is summary offences, may be prosecuted at any time within 12 months after the commission of the offence. Now, in the same article I just quoted from, on June 28, 2017, they said Cox was ordered to report to the fraud squad once a week and has to return to the San Fernando court on July 25th. So he have already stretched the case by 1 month. Now, we're reading in our present law that if your case is, you are only punishable under these fines if you are convicted within 12 months. And Senator Dan has raised the point before about how these cases or these time lapse now can affect us or affect this implementation of enforcement of these present clauses before us. And this, I find I have a little bit of an issue with, because we're coming here to try to put a handle or put a hold on what is happening outside. And we want to make sure what we write or what we amend can work in our present society, in our present institutions, and our present culture. Madam President, there's another article, June 7, 2017. This is an Express article. 17 charged with money laundering in 6 years. Cops provide data. And it went on to say that the Financial Investigations Branch, which was established 6 years ago by the Commissioner of Police, has so far charged 17 people with a total of 52 money laundering offenses. So the amount of people does not impact on the number of charges, so 17 persons. Now in 2018, we learned that there's 27 persons with 355 money laundering charges. And so there was a spike that was alluded to earlier. From 2017 to 2018, we have had a spike of money laundering charges. And I would share my belief into why that there's a spike. But the article went on to say that the money value of these charges was approximately $14,382,000. Again, these figures does not allude to the fine, but there was an important part of the article that I thought was very helpful. They said that there were several other matters for which applications for forfeiture are before the court in respect of those matters, said the police, right? And the article said the Financial Investigations Branch strength has been increased by 55%, from 29 to 45 officers, and this was in 2017. So my hypothesis is that they have increased their number of officers in the FIB. So obviously we'll have more persons looking into these types of crimes. And now we would obviously expect more people, more value for money, more work done. So you would expect your figure to climb from 17 charged to 27. So it may not be that more persons are involved in these types of crimes from 2017, but more have been caught because of the beefing up of the FIB. So that was my interjection into the thoughts that it may be that more people are going towards these crimes or types of crimes. I don't believe that. I think we just have more persons in these institutions who can dedicate their time and effort into charging or convicting persons. Madam President, I did visit the FIU website, and it had the list of all the persons who have ever been charged with money laundering charges. And the figures were not very, very high. As in, for example, the highest I saw in a table was 2 million, or approximately 2.6 million. And that was from our very popular prisoner, Vicky Budram. And there were so many others, and there were even ones that had a fine or a charge of...
Senator Ramkissoon, you're giving a lot of information about the offense, the crime of money laundering. The bill that is before us deals with a specific aspect of the Proceeds of Crime Act. So I need you to, yes, tie the data that you're presenting to the specific clause in the bill, okay?
Thank you, Madam President. So I'm trying to tie it in to clause 53(1) A and B, which speaks about the fines. And I'm trying to put a sort of rationale or try to give some kind of explanation why I think these fines are very exorbitant. And it may be very difficult to say any justice system can charge these offenders with such a fine. That's what I was trying to bring across with the, not as Senator Ramkissoon's opinion only, but to show why I formed this opinion from the figures or the data before me. So, for example, I was trying to share one of the persons who were charged. They had been charged with a money laundering offense of $61,000. Now, these persons have been charged, but they have not been convicted. And I don't know if this is the reasoning behind not being convicted because of the fine basis what they have done. All right, so my second point that I want to, before I move on to the next piece of bill before us, is the fact of the imprisonment or the time of the imprisonment, which is 15 years. And the Honorable Attorney General in his piloting did speak a lot of the FATF recommendations, which is the Financial Action Task Force. And they have been the 40 and the 9 recommendations. And it was revised in February 2012. And one of the recommendations that they gave was where countries apply a threshold approach, predicate offenses should at a minimum comprise all offenses that fall within the categories of serious offenses under this national law, or should include offenses which are punishable by a maximum penalty of more than 1 year's imprisonment. So there is a recommendation for countries should criminalize money laundering for a maximum of more than 1 year, so not less than 1 year. And they said for persons who had a minimum threshold for offenses in their legal system, they should be punished by a minimum of more than 6 months. So I find for 1 year or 2 years, but 15 years, Madam President, again, I find is a little bit harsh. It's in our existing legislation, and now we are trying to double it. So existing 25 million and imprisonment to 15 years, and now if you do go to court, you can have a fine of 50 million and imprisonment of 30 years. I really do find these, based on what we have seen in our history or who have been convicted, these fines do not deter or do not prevent such petty or small crime offenders. The next piece of legislation that I want to speak about is the Financial Intelligence Unit of Trinidad and Tobago Act 7201. And I want to commend the director of the FIU who have been consistently providing annual reports. I have not seen any other unit who have such a dedication, and that is very commendable. What I wanted to highlight was the amendment, section 27(4), which states a person who contravenes regulations made under this section commits an offense and shall be liable to a summary conviction to a fine of $500,000 and to a further fine of $25,000 for each day that the offense continues. And it went on to say B, on conviction on indictment, a fine of $1 million and to a further fine of $50,000 for each day that the offense continues. And I felt that this was, in fact, captured in clause 21(1). So I'm not certain as to if this is a repetition But the only change in word is the regulations. And so the only change from clause 21.1 and 27.4 was the terms contravene regulations. And I didn't know why we wanted to put in this clause, because if you look at the regulations, Madam President, it is there on the section, and I would read it out, but I'll just tell you what section it is. It is under regulations, clause 36. So it is there. So my question to the Attorney General is probably, is this a repetition? Why the need to put in this clearly when it is encaptured in the bill, existing law, right? All right, and my other comment in relation to this is when I did look at the regulations, if we wanted to pull out critical penalties in the regulations into the existing law, then why not pull out the regulations 11.3, which had a much more critical penalty that was not encaptured in the existing law. And that was basically for persons who took information from the director unwrongfully or without permission, they would be fined and charged. And that was not captured in the existing law. So if I felt that if we wanted to include something from the regulations, that one should have, and that is section 11.3 from the regulations. My next point is on clause 18G 2B. Excuse. And this is on the warrant under subsection 2. And many senators have spoken about it. But I just wanted to bring one extra point into it. And that is, clause 2B, a warrant under subsection may include the requirement to provide a police officer with any information or any explanation or any information in accordance with subsection 1B. Great. But then in that same breath, clause 18G, clause 2E states, nothing in this section shall be construed as requiring any person to give any information which may incriminate him. So we're trying to put in 2E to bring a proportionality to the bill or to the clause of the warrant. But then I'm thinking, for me, we're giving the power to the police, but then we're taking it away in the same breath. I went to this forum on dispute resolution, and I met a lot of police officers who was attending this course. And their concern during, or issues raised during the training was they don't have a lot of rights or they don't have a lot of privileges when questioning persons who are under the arrest. And I felt that, okay, there's a warrant. We are trying to give the police some power here to get more information than normal, or maybe that is in the existing remit or powers of the police officer, but yet in the same clause, we're telling them, okay, you can only do this much. After that, you can't get any more information because this may incriminate the client before you or the person who's being charged. So that was just my 2 cents to that particular clause that has been discussed during the debate. My other piece of legislation I would like to deal with is the Customs Act, and that is 7801. And the comment made was that there is to provide criminalization of failure to provide information. And I was a bit uncertain on how we as a parliament, even the administration before us, how they are going to do this, or how they're going to criminalize persons who are not providing information. Because in my line of work, I deal with procurement of materials. I was very surprised when reading the Customs Act that there's a whole schedule on what type of iron to import, zinc to import, all the different alloys. I was very impressed, honestly. I never knew these things existed. But in the industry, Madam President, it is very difficult to get good material because we are a developing country, so we get a lot of substandard material in our nation, and especially in our oil and gas sector. So how come we have a customs schedule that deals with this, but yet we're still receiving poor or substandard material such as pipes, valves, pumps, when this is addressing the schedule of rates? So my question is, how are they checking it? What are we asking the custom officer to do? In the industry, Madam President, we have to get special equipment to test your material. We have to use a positive material identification X-ray machine to try to tell you what type of silver or gold or alloy it is. Here we are asking our customs officer to tell us that it has met these standards. How do we intend to get this result from them? And I could not see that. Because we're not providing them with material to test our pipes or our valves or any of our equipment. So how is it that we're going to tell us it has met this? Now we're going to provide them with a MILTA certificate, which is the data. So we're asking the clients now to provide the custom officer with the information. So I would provide you with a MILTA certificate to tell you the type of material, the chemical properties, and how much I paid for this. But you can't tell me what I provided you is false or true. You have to just be like, okay, this was provided, this matches your test, your MILTA certificate, if they know what the serial number is, if it's going to match.
Senator Ramkissoon, I'm sorry. What specifically in the bill are you dealing with? Could you just, I'm just trying to get you to, yes.
Okay, Madam President, I apologize. So I'm trying to look at the clause 23A and clause section 22284, right? Unfortunately, I have to get the people. So we are asking, okay, so we want to retain people. Okay, let's start with that. We want to, for members of the public or anyone who is dealing with the customs division to provide paperwork. Correct, that is a normal. What we're asking them to do is now we're changing it from retaining it to 1 year to 6 years. Okay, great. But what I'm trying to say is the paperwork that's presented, there's very little that they can do to say, okay, this matches what has come into the country. And we are now holding them accountable for something they cannot be accountable for in some aspects. Now, when we think of laptops and computers and phones, yes, but this schedule doesn't only deal with this. The Customs Act deals with so many different articles of materials, machinery, electrical, so many different things. Remember, everyone passed through customs. So we might be looking at one group, but we're impacting on all the other areas. So that's why I was trying to make the example. So maybe I should have said that before I brought into the example of my experience in procurement and how it is not a simple test to know what is before you, what has been brought in. And it is difficult to ask a whole persons accountable for something they cannot be held accountable for. And that will bring into my point, which was raised. We are in 2018. Now, these prices, we're giving them 2024. That's 6 years after. Did I do the maths correct? That these persons can still be charged taxes if an error was made. So you had an invoice, and there was an error in it. And 6 years later, someone picks it up and says, company X has underpaid because the invoice was doctored and this is not the actual price they have paid for it. Who now pays that? These goods have been sold, these goods have passed on. What are we trying? I have no problem with keeping the documentation for 6 years, but why are we now asking them to pay taxes or fines or fees, additional fees, 6 years after? And that is, I think, is very bit unfair. Actually, it is very unfair because 4 years later or 5 years later, to having to pay something that has been passed on is very difficult to do. And Madam President, we're not taking into consideration human error. So if, for example, a custom officer does make an innocent error and has undercharged you, should the company or the owner now tell you have to pay more fines because of a human error? And that is the other side or the other spin to it. So yes, we can repeal it, but what does that mean? 6 months to repeal, yes, but really there's so much that would have been lost, there's so much to prove in that factor. So keep your documentation, yes, but charging you 6 years after, I think there should be a limit, probably 2 years maximum. Because 6 years is such a long time, Madam President. The goods would have passed. We would not want to keep goods, equipment that long in any field. The other points that I had highlighted, which was section 2284, where an importer or exporter or a person having an interest in the importation or exportation of goods fails to provide the information or documents required under subsection 1 or to subscribe to a declaration as required under subsection 3, he commits an offense and is liable to a summary to a fine of $150,000, right? So that's the amendment. In the present existing legislation, there is for the goods that the person will not receive the goods, but we have taken out that, and I would like to know why. So if the person doesn't have their paperwork, they just have to pay a fine of $150,000, I believe. They have to pay a fine, but they will get their goods. So, Madam President, are we now encouraging persons because they don't want to pay a large sum that they're just going to willingly lose their paperwork, pay their fine, and receive their goods? So, I'm trying to find the actual point because the existing legislation says, yes, section 4, refuse entry or delivery of such goods. So the existing legislation takes that into consideration. They said you refuse, but we're taking out, we're repealing this part, and we're changing to just a fine. And I find that that's a bit a loop, and it can encourage wrongdoings. So we should really keep that as part of the existing legislation, keep that in the amendments, and we can also add the fine, which is not a problem. But we should definitely not allow them to keep their goods or have their delivery of their goods. The last point is the Exchange of Control Act, which deals with clause 6.2.6. And this is the exemption from the provisions of section 22(1)(c) of the Act. And that is the importation into Trinidad and Tobago of bearer of negotiable instruments brought into person or any baggage of the traveler to the extent of the US 5,000 currency of value. So I know that a lot has been said in the other place about the bearable goods and the currency of the 5,000 US. And I did appreciate the Attorney General's comment that this can be easily amended in way of a financial bill, which we don't really have a vote on, but we do have a voice. And I did find it settling to learn that this can be amended at a later time to increase it to the 10,000 US, if so be it, because the US has it, Australia, all these different countries have the consistency of the 10,000 US as the need to declare. And we wouldn't want the declare line being extra long because everyone has 6,000 US coming into our country. And Madam President, I have really tried my best to not make this as confusing as it sounds because it is the time constraint we're trying to work with in the Senate. And I have touched on 4 of the 5 bills before us. It is very difficult to vote on an omnibus bill when you don't agree with all the amendments. It really does put someone in a very difficult position because yes, you support the mutual assistance in criminal matters, you support some of the amendments for the procedural crime, but you don't support all of it. And it,
more minutes.
Appreciate it, Madam President. And also I appreciate all your guidance in this particular debate because it was one very difficult for me because I tried to go through all my points and all my ideas in such a precise manner and also tying it in with the legislation before us, or the amendments before us, sorry. So, Madam President, I do not support the money laundering fines and also the addition of the summary conviction because clearly in item 42 it says it's an unindictable offense. Also, I do think that the customs fines and the customs fine that can be retroactive 6 years prior is a very unfair person to any company or business person who is not myself because I do not own a business, I am an employee. And I also do not believe that having all these in one bill was a best approach for us to evaluate it as senators. And I always appreciate the Attorney General and his team for being very ambitious and putting their best foot into trying to change the paradigms around us in terms of the criminal aspects and the offenses that we see. We do hope more can be convicted and not just charged. So maybe we can look at lowering the fine so it could be something that we can really operationalize and really have persons held accountable and then really deter them from going this way. So, Madam President, I did say a lot. I do thank you for your ears and all who have been listening. I thank you.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President, for the opportunity to contribute to the debate on this bill, which is an act to amend a series of legislation set out in the bill. Madam President, let me start off by saying that just before taking up this role, I was employed with one of the largest financial institutions in the world. And when I listened to Senator Ramkissoon and the severity on the $25 million fine, and when I listened to Senator Sobers on the issue of sovereignty, I feel it is very important that I establish from the outset, on the issue of sovereignty, Madam President, with all due respect, in the world of international finance, little attention is being paid to territorial sovereignty and citizenship. It's all about the money, and it is all about the currency in which you do business and the method in which you do business. And there's very little room for sovereignty. And my employer, Madam President, found that out the hard way. Despite its size and its spread around the world, on account of business it did in Mexico, it faced a $5 billion fine in the United States and incurred a cost of several billions of dollars to satisfy the Department of Justice in the United States that it could clean up its act and continue to hold its license in the United States. The consequences, Madam President, of the loss of a license to operate in the United States would have been fatal to the bank and would have caused tremendous loss not only of jobs, a tremendous loss to the community in which the bank operates. So the issue of money laundering, Madam President, and the issue of the passage of the proceeds of criminal activity through the financial system is not a simple matter, and it defies sovereignty and it defies citizenship. Notwithstanding, Madam President, notwithstanding that, I want to make the point that not every agreement to cooperate with an ally means that you have condescended, you have conceded, or you have eroded your sovereignty. In the Committee of Nations, Madam President, the need to make such concessions and to facilitate the movement of information has to be balanced, of course, by the fundamental rights of the citizens of each nation. But the need to share information is something that is fundamental to operating in the global environment. Madam President, parallel to that life I had, a lot of people felt that I was employed as a journalist. A lot of people have forgotten that I'm a lawyer by profession. But parallel to that, I was also a columnist with the Express. And I wrote a few times, Madam President, on this issue of the Financial Intelligence Unit. In 2014, the report of the FIU highlighted $1.2 billion in suspicious transactions. And for a country of this size, I found that to be an incredible number. And by my calculations, that meant that on average, the $1.2 billion, I believe, dealt with about 30-something transactions. And I asked the question in my column, who in this country has $30 million sitting around that they cannot account for? Madam President, the lotto tomorrow night is $20 million. I don't know if you'll play. But
I'm sure she does not get
if any one of us had 20 million, Senator Ramdeen, I would think that we could account for it. But here it is, the report was saying $1.2 billion could not really be explained. And in the world of banking, there is something called an SAR, or an STR, Suspicious Transaction Report, or a Suspicious Activity Report. And who is the person who can approach a counter in a bank, in a financial institution, Madam President, with $20, $30 million and not be able to account for it? And I found that to be amazing. But Madam President, a few months ago, when the FIU's report for 2017 was published, well, I was even more astonished, and I think that Senator Ramkissoon and Senator Sobers and all of us should take note. On average, because in this case, the FIU was reporting $22 billion in suspicious transactions. Where in this country's economy, Madam President, we could have 22 billion. Madam President, I'll tell you this. My eyesight is not as good as it used to be. And I had to pull out my magnifying glass to count the zeros because I was looking for a full stop. I could not believe I was seeing 2, 2, 0, 0, 0, 2, 2, comma, 045, comma, 740, comma, 881. What that means, and that relates, it's split in two. 13 million, we have two categories, as I said. We have transactions which were completed and transactions which were attempted. So let's deal with completed. and completed related to the insurance companies. And in the insurance companies, about $7 billion in transactions, suspicious transactions, were completed and reported, $7 billion. And in the banking system, $13 billion in transactions were attempted. And those were only 54 transactions. They were not 200,000 transactions, each valued on average $50,000. So it means, Madam President, while I was wondering and writing in 2014 about 1.2 billion, 37 transactions, the FIU is saying to us that in the banking system, on average, there were 54 transactions with an average value of $256 million that people attempted to move through the financial system. Mr. Vice President, that is more than the budgetary allocation for some ministries for the fiscal year. That is not a simple matter. And what the FIU report is saying to us, Mr. Vice President, it is saying to us that certain things are happening, particularly as it relates to criminal behavior, criminal intent, and dealing with the proceeds of crime, because I wrote, Mr. Vice President, a column once, which I called The Keel of Crime. And if you know from your yachting or boating business, the keel is the steel framework upon which the vessel is constructed. And I was making the point, criminals are not committing crime for fun. Criminals are committing crimes for money. And if you deal with the movement of the money, as the AG likes to say, follow the money, if you deal with the money, then you can deal with the crime. And what this bill proposes is, in many respects, is to strengthen our ability to deal with the money. And here is where we separate the sheep from the goat. If you win the lotto and you can go, I would go to the credit union. You could go, you could approach the counter. But if you are a goat looking to move 256 million, the banking system is telling you, we have no room for you. And by strengthening FIU, customs, and all the pieces of legislation that we need to fix, we are fixing our ability to deal with money, Mr. Vice President. Because if you don't and you hold on to red, white, and black and cry sovereignty, the foreign banking system will deal with you. Because you will not be able to deal with credit card transactions, and the merchants would not be able to do business because we are dealing with money and we are dealing with being part of an international financial system. So in my view, Mr. Vice President, there are four things I set out to say. One is that there's a rationale for this piece of legislation. It's not whimsical. And the rationale, in my mind, fits squarely into what we are dealing with in relation to crime. There's going to be an impact with this legislation. There's a necessity. And finally, it is an important part of continuing the work that is to be done by the FIU. And let us talk about the rationale. Well, I would say, Mr. Vice President, that the most important thing, the most important reason for the legislation would be to strengthen the FIU. And in the bill, I would go to Section 17. And Section 17 is a simple provision that gives the FIU the authority to publish in the Gazette and in 2 newspapers a list of countries identified by the FATF as non-compliant and, more importantly, not sufficiently compliant with its regulations in the jurisdiction. So that, Mr. Vice President, is a method of strengthening the FIU in doing its work. When you go to Section 18G, when you go to the proposal to amend Section 18G, again, dealing with documents and the requirement for persons to submit documents and the power to deal with the warrant, that is again an attempt to strengthen the FIU. And throughout, the clause which seeks to amend Section 27 of the FIU Act, it's an attempt to strengthen. Alongside that, Mr. Vice President, alongside the efforts to strengthen, I think the AG has made it clear, and he's made it clear in the other place. Again, we are not operating, as I said at the opening, on our own. We are operating in the context of the FATF and CFATF. And whether you like it or not, whether you feel that it interferes with your sovereignty and all of that, the fact is that it is something that, as a small nation, we require. We require the support. And the FATF, as the Attorney General has set out, has made certain recommendations. And some of these provisions are meant to comply with the FATF's recommendations, or in some cases, the FATF and the CFATF. Some of them have meant, the intention is to comply with some of those recommendations, because the country, as the Attorney General so succinctly put together for us in his piloting of the bill, a series of recommendations that must be adhered to, because the country goes through periods of review, and there is a risk. There is a risk, and some of our neighbors, Mr. Vice President, have been blacklisted. There is a risk that will come, if it comes at a price that Trinidad and Tobago cannot afford. You cannot afford. And alongside strengthening the institutions, strengthening the law to enable the institutions, we are also meeting some of the requirements of the FATF and the CFATF. Mr. Vice President, these provisions, as I say, didn't materialize just like that. Every provision in this bill can be linked to the FIU's report, which, as Senator Ramkissoon says, they render every year as required, and or link to a CFATF or FATF recommendation. So there is a process that is set in train which brings us to this bill. And let me give you an example, Mr. Vice President. In June 2016, the FATF published the 4th round mutual evaluation report for Trinidad and Tobago. And as I said, you would see those reports appearing on a periodic basis based on reviews conducted with the country. And in that report, in the executive summary of that report, and I would read that section, the FATF is telling the country this, and I quote, "The large volume of currency declarations being reported by the FIU-TT to the FIU-TT by the Customs and Excise Department, coupled with the increasing amounts of reports the FIU has been receiving from the money value transfer services providers, that is like your Western Union and so on, and the monetary value of cash seized by Customs and Excise Division are indicators that significant amount of monies are being moved across the border." This is 2016. So they're saying to us, because we recognize in the world of finance, these money value transfer services had been flagged as a vehicle for money laundering and the movement of cash across borders, had been flagged. And the evaluation report says that we've seen it. We've looked at the declarations. We've looked at what has been submitted to the FIU. And we have looked at the cash being seized by customs. And we recognize that it is an area of risk that must be dealt with. So there we have, Mr. Vice President, a provision being introduced in this bill, a provision to deal with the value of instruments which you can carry on your person or in a bag as you move across borders. And that is the rationale for it. It is tied to what the customs are saying, what the FIU is saying, the experience in dealing with cash, and it finds its way from a 2016 report into a bill that is before us so that we can plug a loophole or a hole that has been highlighted to us. Mr. Vice President, the report also, because, you know, in this country, we do not believe, or we're not convinced as a country, that terrorism affects us. We do not believe so. But the reports have been showing, whether or not you believe that there is terrorism in the form of bombs and guns out there, and maybe here too, whether you believe the FIU and the other agencies have been saying to us that there is evidence in the financial system of terrorism money making its way through our country. And Mr. Vice President, I don't have to tell you, I don't have to tell anybody. The fact that these casinos, for example, have sprung up in the world of money laundering and in the world of dirty money, that's a red flag bigger than the flag we had up at Makoya. Is that Makoya or down by the stadium? Well, we had one by Makoya. That's a red flag bigger than that. We are telling the world we are open for dirty business. And of course, Mr. Vice President, in one of the joint select committees of Parliament, there is a gambling bill. And I, above everybody, even though I'm going to play the lotto, I look forward to the day, Mr. Vice President. I look forward when I see what is happening in my community, in Rio Claro and Bish and Mayaro, when I see, I never thought the day will come when I would stand by the roundabout in Rio Claro, little Rio Claro, coffee, cocoa, fig, dashin, little Rio Claro, and stand in the junction by the roundabout and see 3 casinos in front of me. 3. I never thought I would walk into one of the watering holes and see 3 walls of machines, but people playing all day. And in the world of dirty money, that is your biggest red flag. That is your biggest red flag, because it is based on cash, and it allows for the collection, for the deposit, and for the movement of dirty money wherever it has to go. So that, likewise with terrorism, the reports have been saying to us, you have people who are using your country, because, Mr. Vice President, there are many countries in which there are severe restrictions on the receipt of cash in the banking system. There are countries where institutions must report receipts from certain places and certain people. But if we have a low fence in Trinidad, if we have a low fence with our regulation, and if we have a low fence with our reporting, then it is open for business. And anybody in the business of terrorist financing will step over the fence. Not necessarily to do damage here, you know, Mr. Vice President. To clean up and make Trinidad the source of their deposit that moves into another place. Merely a conduit. Merely a conduit for the movement of terrorism funds. And that is what it is. The FIU is saying to us, and the AG is saying to us, we have to strengthen, we have to clean up. And this is not the last bill of this nature that would come to this Parliament. And the more bills of this nature, Mr. Vice President, that come here will tell us the more attention we are paying to the loopholes in our financial system and our ability to plug the flow of money, because crime is about the business of money. There's no other reason for crime. Mr. Vice President, I listened to Senator Sobers, and I appreciate the fact that he treated the issue of enforcement in this in a way that the failure or the deficiencies really doesn't reside in a particular political administration. I have said on many occasions that we in this House and we in the Parliament could produce the best legislation, the best, but it falls to people outside of here to implement and to get the business done. And again, the FIU reports and the periodic reports from the FATF have pointed to challenges in moving from suspicious activity and suspicious transactions to charges and convictions. And you have to remember, in some jurisdictions, the equivalent of the FIU, they have their own prosecutorial powers. And in our jurisdiction, the FIU does not. So the FIU provides intelligence to law enforcement. The FIU provides information for those who have the prosecutorial powers and the investigative powers, and rely on those institutions to do what has to be done. So of these, all these SARS, and last year, in the last report, there was an increase in the reports from the banks. There was a decrease in the reports from the casinos, and overall there was an increase. So it points to more reports reaching the FIU, more analysis to be done by the FIU, but it also points to a greater backlog ending up somewhere. Because if we not move into convictions, in the face of the volume of reports in terms of money and numbers, if we're not moving the prosecutions, there is a bottleneck somewhere in the system that one day the Attorney General may have to come and ask us to deal with. So let me just go back to Senator Mark because he's not here. When Senator Mark, and it was reported in the newspaper, Mr. Vice President, and I have to respond. When Mr. Mark said that the increase in the volume, in the value and volume, he said $22 billion in questionable money means that corruption is flourishing under the PNM. Well, it is just like workplace accidents, Mr. Vice President. People believe that the more reports of injury in the workplace you have, the more unsafe the place is. Well, it's not like that. The more reports means that the system is working, because you do not want to have a situation where your reports start to decline. You want to see that the reports are increasing. So when the banks say, when the FIU says that the number of reports, when the FIU says the number of reports are increasing, it is a good sign. And when you see billions of dollars in transactions being flagged, it is a good sign. That part of the system is working. It leaves you to wonder, where is the money coming from? The fact that the institutions are flagging it is a good sign, but where is the money coming from is a question that we have to confront. And the number, as Senator Mark referred to it and blamed the PNM being in government, well, if it's increasing, we should remain in government. There are a few factors. One is, if the reporting system is improving and getting better under, so leave us here. Based on Mr. Vice President, the reports has to do, the increase in reports has to do with a few factors. One is the increase in registration by entities which are required to report. So in the period covered by the last FIU report, there were 267 more entities reporting. In fact, that represents now about 10% of the numbers. So right now we have 2,502 institutions registered with the FIU to report, and in the last period, that number had its highest increase in any year since the FIU has been reporting, and that contributes to more reports of suspicious transactions. There's been an increase in compliance, Mr. Vice President. In 2013, there was a 68% compliance rate by reporting institutions. In 2014, it went up to 74%. 2015, 84%. 2016, 86%. And 2017, 88%. So in 2016, we've seen from 2013 to 2017 an increase in the rate of compliance by registered institution, and that should result in an increase in the activity reporting. And Madam President, credit to the FIU. The FIU has consistently maintained its presence and has conducted awareness training and all of that. And in the last reporting period, the FIU conducted close to 1,200 awareness sessions for institutions around the country. And all those things, Madam President, will contribute to a more buoyant system of reporting and a better environment in which we could deal with this issue of money laundering, terrorist financing, and the keel of crime, which is which involves those individuals who are in crime for money and who need to get their money into the financial system and out of the financial system. As I close, Madam President, I just want to, as I made the point about wanting to know where the $22 billion comes from, and it's important that we know where it comes from because you want to know why it has been suspicious. But I'll just point to two factors. One is that the FIU has said that approximately $10 billion in transactions relate to attempts at fraud and forgery. So it is not so much drug transactions or those type of transactions or profits and proceeds of drug, but it has to do with fraud and forgery. And another important element I want to flag is that the FIU is saying 307 of those transactions, Madam President, were transactions which were US dollar transactions. And the value of that, out of the 22 million TT, 3 billion US dollars. And of those transactions, those 307, 12 of those transactions amounting to 2 billion US dollars. So divide 22 billion by 12, and you would see the amount of the volume of the US denominated transactions which tried, and in some cases succeeded, and some cases did not succeed. And that tells us, Madam President, that this issue of sovereignty, while it is important for the health of our financial system, we must consistently bring legislation like this if Trinidad and Tobago wants to continue to be a player in the international financial system, because there are consequences. And in relation to two areas, suspicious cash, the last report of the FIU tells us, with the biggest red flag, that you are in the game. And the reports on terrorism financing, the last report tells us 111 transactions related to the financing of terrorism. So if you don't believe that we have the presence of people who will plant bombs, you better believe that somebody in our system is facilitating the movement of money intended for terrorist action. I thank you, Madam President.
Senator Obika.
Thank you, Madam President, for allowing me to make my contribution to this miscellaneous provisions, mutual assistance in criminal matters, proceeds of crime, Financial Intelligence Unit of Trinidad and Tobago, and the Customs and Exchange Control Bill, 2017. Now, I must acknowledge the sterling contributions made by the senators who have went before me and those who have gone in the other place. My focus, because we have significant, illustrious legal minds who have contributed prior and who will contribute after me, I will focus on aspects of, on the concept of consultation and aspects of the Customs Act, as well as the FIU and the way in which they have decided to make the amendments and the impact that that can have on our whole legislative agenda going forward. Now, I wish to begin with the FIU amendment. Madam President, it is disturbing, not in the least, when you look at Section 18G of the FIU Act, and where it says any officer with no rank specified will be able to execute the matters that are there regarding a warrant and so on. Now, I'm not sure to what extent, in terms of breadth and depth of training in anti-money laundering, counter-financing of terrorism, that each and every single police officer, with all due respect, as I said, my grandfather on my mother's side was a police sergeant, rest his soul. Each police officer has in Trinidad and Tobago. So it is very disturbing when they didn't specify, okay, maybe a particular unit, officers of a certain rank if you decide to go across the entire force, but you basically make it that any officer. And that, to me, is dangerous. And for this reason, I wish to start by outlining what we look at when we talk about money laundering and counter-financing of terrorism. Now, the Egmont Group, all countries, and regarding the FIUs, the Financial Intelligence Units, all countries are expected to have a financial intelligence unit, which would deal in suspicious activity reports. That's their currency, all right? Or suspicious transaction reports, or unusual activity reports, so UARs or SARs. Now, the Egmont Group promotes international cooperation amongst FIUs. However, again, I'm not sure that the level of training that a compliance officer, for example, in a large financial institution will have, you will expect each and every officer who is precepted to also have. I stand to be corrected, but I believe that it's next to none, all right, in terms of being sufficient to carry out the tenets of the law. Now, money laundering, for those who are listening, has three basic characteristics. So you have placement, after placement, you have layering, and then you have integration. Now, I'm not going to make this a class on money laundering, all right? So I will stop at that point. Persons can research on their own. Google is very extensive in the explanation of those terms, Madam President. But I believe that if it is, you are saying that a police officer can execute the law to the fullest, they must have full training and not 2 weeks or one session somewhere. All right, and I believe that that part of the law should be revised. Now, I want to go on to and I quote the source for the Hansard, a document by CFATIF, as the Anti-Money Laundering and Counter-Terrorist Financing Measures, Trinidad and Tobago, the Mutual Evaluation Report for June 2016. Now, the findings here are so significant, and so the gaps are so vast that it's embarrassing being a citizen of Trinidad and Tobago. Nonetheless, we are here to bridge those gaps, all right? And I would like to ask if, of all these recommendations that were made, why is it we are only choosing these minute aspects, all right? And it would beg the question, Madam President, it begs the question that if the changes in legislation, read the FIU, are guided by, and I hope are guided by anything other than really and truly fulfilling the recommendations of CFATIF. All right? Because really and truly, especially when you look at that aspect of lowering it to the rank of any officer. So someone can just go the 6 months training, they've passed out, they have not had any extensive training or experience in the process of the courts in terms of anti-money laundering or terrorist financing, and they can execute a warrant. They can decide to be part of this process that can end someone's entire name, their good name. Because in Trinidad and Tobago, once you are fingered in the eyes of the public, unfortunately, you are guilty, even though our system is counter to that, which is really you are innocent until proven otherwise. So one of the recommendations on page 10 regarding the assessing risks and applying a risk-based approach is that the authorities of Trinidad and Tobago have not fully identified or assessed the money laundering and terrorist financing risks of the jurisdiction, neither do they fully understand these risks. I feel embarrassed even reading that. So I won't read the others because they are even more damning. But the reality, Madam President, is if this is the case for our country, how do we expect the newly passed out officer to be on top of things? All right, so I think they really need to change that. The recommendations here are too many, and I believe really and truly if this government was serious in any way in terms of addressing these recommendations, we would be looking at this bill in a different way, and we would definitely be thinking about a joint select committee of Parliament. Another point that I would like to raise regards the Global Forum on Transparency and Exchange of Information for Tax Purposes, the plenary meeting of the 15th to 17th November 2017, Yaoundé, Cameroon, where it was outlined, the Attorney General pointed to this fact that Trinidad and Tobago is the only non-compliant regarding the exchange of the exchange of information regarding the other members. So, however, if that is the case, you are the last student in the class, being the country Trinidad and Tobago. It should mean, is it that we are just trying to make sure that we are not last, but probably second to last in the next assessment? Why not bring something that is much more substantive to the Parliament so that we can jump the ladder, all right? So I think a serious rethink of the entire approach, Madam President, needs to be done. I would like, with your guidance, to read just a brief part of the FIUTT's annual report for 2017. And this is in the preamble by Susan Francois, the director. She says at the institutional level, the FIUTT was able to increase its complement of staff in the analysis division by 5 analysts, and in the compliance and outreach division by 7 officers. However, while the sanctioned staff level is 49, which is a very small number in consideration when you compare it to the investigative staffing component of even maybe one major commercial bank in Trinidad and Tobago, I think 49 should be much more than 49, but a number of positions are still vacant, all right? And they plan to fill them in the coming year. But I believe that really and truly, if it is, we have so many SARs coming forward and UARs coming forward to FIU, and we are getting much more compliance across the system, I believe that we need to really relook at the staffing complement of the FIU to really make them competent. All right. Now, also, Madam Francois outlined, and I read with your permission, looking forward, the FIUTT is a critical agency for Trinidad and Tobago to be able to demonstrate effective implementation of FATF 40 recommendations. In the year ahead, therefore, the FIUTT's main priorities will be producing useful intelligence reports in a timely manner. How can you produce timely reports given the fact that you are understaffed already? And even when you reach a full staff complement, you may not have the capacity to handle everything. Actively promoting cooperative relationships with reporting entities, providing a resilient learning environment for new staff to ensure that they are fortified for the tasks ahead. And I hope that this is not a veiled plea for looking at the absence of training, but rather that there is funding for training, and they are mainly stating the obvious. Upgrading the existing information technology infrastructure by implementing a secure electronic communication system with reporting entities. This, Madam President, is a very alarming statement. Is it that at the moment the electronic communication system is not secure? So persons' personal financial information, which based on the agreements with FATF and CFATF should be private and confidential except to the reporting agencies, may actually not be private and confidential. Then this information should be brought to the authorities and it should be corrected with immediate effect. And I really hope the Attorney General in his winding up can bring some clarity as to whether or not there is a breach or not. And Madam Francois outlined some others, but I won't go there. All right. Now, Madam President, I turn to the substantive ethos of the presentation by the Minister of Agriculture. All right. The thrust of his argument in that, no, before I go to the thrust of his argument, the Minister mentioned Rio Clara and being little and talking about cocoa. But I would like to remind the Honorable Minister that there was a time in Trinidad and Tobago where cocoa was king. And at the moment, the farmers and the stakeholders in the cocoa industry are committed to a revitalization of the sector. And by virtue of a change in the colonial-style agreements that they had that pervaded in the past, they are now able to increase their profit, their revenue potential by 1,000%, 10 times effectively, because the prior agreement no longer stands. But as an aside, I was just responding to the Honorable Minister. Now, the other issue that I find it, I'm not sure if the Minister misspoke, but he said that increased reports of suspicious activity is a good thing. I posit that only under a PNM government, that could be good, because that's money laundering. Now, Madam President, the issue of international finance, the Minister of Finance said that defies sovereignty. And he stated that after it has to be balanced by the fundamental rights of citizens. So he's saying, yes, there's a new world we're living in, there's a new world order, and in the world of money laundering, you basically can't worry about sovereignty, because of international finance operates by different rules. But I would like to share an article by Yale Global Online that for the Hansard it's yaleglobal.yale.edu/content globalization versus economic sovereignty. All right, so the article commented on some commentary by a Chinese researcher, Pang Zhongying, on Friday, December 2nd, 2005, where he states, and I read with your permission again, almost all countries in the world have accelerated their tempo of economic opening up since the beginning of the 21st century. They hope to integrate their domestic economy into the global market and to develop economic muscles that can punch a worldwide weight. Nothing is wrong with that. We want to punch above our weight in Trinidad and Tobago. However, for any country, opening the economy to the outside world is by no means a free lunch. The policy will inevitably come at a cost. So what is the cost? That cost can be perceived to be a weakening of the nation's economic sovereignty. All right? So, yes, the Honorable Minister said that in the world of international finance, the issue of sovereignty should be compromised somewhat. However, the issue is, it is the weaker nations that usually do more of this compromising, and it's the stronger nations that really set the rules. And as a result, we should always be guarded against giving up our sovereignty, given this scenario. And there are some examples that are very familiar to all of us in the Caribbean. One would be the International Monetary Fund. Another would be the World Bank. So we know that, and for those reasons, we have institutions like the Caribbean Development Bank, all right, which really is an attempt to protect our sovereignty as a CARICOM space. So that is the extent of my contribution regarding the FIU and the response to the Honorable Minister of Agriculture who went prior. At this time, Madam President, I would like to look at the Customs Act and the amendments made therein. And the entire aspect of my contribution regarding this bill, this piece of legislation, is the concept of consultation. All right? Now, I wish to share some views on consultation. Dwight D. Eisenhower, we all know who he is. I assure you that it is our desire and intention to keep the doors of consultation always and fully open, he said. There must never be a final word between friends. This is in view of the impact of the amendments to the Customs Act on the players in the industry. Test ideas in the marketplace. Donald Rumsfeld starts, test ideas in the marketplace. You learn from hearing a range of perspectives. Consultation helps engender the support decisions need to be successfully implemented. And I state here today, without consultation in this bill, we lay waste basically all our efforts regarding the Customs Act today. And from the writings of Baha, the great being saith, the heaven of divine wisdom is illumined with two luminaries of consultation and compassion. Now, the UK consultation and principles, all right, they said that we will use digital methods to consult with a wider group of people at an earlier stage in the policy forming process, at an earlier stage, Madam President, not after the fact, not when you have already come to a hard position in the policy forming process. We will make it easier for the public to contribute their views, and we will try harder to use clear language and plain English in consultation documents. We will also reduce the risk of consultation fatigue by making sure we consult only on issues that are genuinely undecided. Now, I say this and I turn to our local context. In Trinidad and Tobago, there is a National Trade Facilitation Committee, all right? And on this committee, and I quote from an article in news.gov.tt, March 24, 2016, where the Honorable Minister of Trade and Industry on the 20th of March was quoted as stating that the newly established committee, the government is aware of the many challenges faced by traders on a daily basis, namely burdensome procedures, time lags in importation and exportation, loss in perishable goods, and lack of transparency. The agreement on trade facilitation seeks to alleviate, and this really comes from the global body, from the WTO, seeks to alleviate these issues by creating a reliable, fast, and cost-effective trade environment that will benefit all trade-related stakeholders. She challenged the committee, all right, thereafter. Now, furthermore, it says here the establishment of this committee on the implementation of the TFA, Trade Facilitation Agreement, will build on the government's objective of enhancing competitiveness and so on and so forth. That will be tested as I continue my presentation. On the committee, we have many members, one of which is Mr. Nicholas Ruston of the Customs Clerks and Brokers Association. Also, you have the Ministry of Trade represented and so on. Now, I turn to Clause 5 of the bill, which is basically the bill that the clause of the bill I've been speaking on indirectly. So, Madam President, the Clause 5 of the bill would seek to amend the Customs Act, among other things, to give the Comptroller of Customs the power to detain subsequent shipments of an importer where an adjustment is made to the value of his goods and he has not paid the adjustment and fails to commence proceedings before the appeal board within 6 months from the date of notification. So what does this mean to the average Trinbagonian worker in their small and medium enterprise business? This means, Madam President, that the Comptroller of Customs has now been elevated to the status of judge, jury, and executioner of many an enterprise that depends on imported goods for their survival. I qualify that statement, all right? Because we know that there is a tax appeal board. However, the way in which this amendment is framed because timing is all that matters in business. Timing of cash flows, timing of a decision, timing of a change to a business model. In the case of an importer, timing of the arrival of your goods so that you can get them to market and you can recoup your capital in the shortest possible time and generate some profits. Now, if the timing between getting your matter resolved from an undue, I wouldn't say unjust, but let's say undue, meaning you can't afford to pay, if that word sits correctly, you can't afford to effect the payment, and the timing between that decision by the Comptroller of Customs and the Tax Appeal Board to allow you pay what may be a more due payment or where you can find the funds to pay, and all your future shipments are detained, it means that you are unable, and this point was hammered by prior speakers, so I won't go too much on that. It means that you're unable, really, to liquidate your goods, and you're unable to stay afloat. It may mean the death of many businesses in Trinidad and Tobago. So put simply, now this is a small island open economy. Put simply, you have to import to survive in many an industry, even education. If you can't import, you can't survive. All right? So, but in this scenario, we have a Comptroller of Customs who can, on a good day, or I dare say a bad day at the office, utilize discretion with no checks and balances and charge what may be an arbitrary fee for the shipment of a particular importer. This is the first major problem, Madam President. Where are the checks and balances to this decision? All of the frameworks that guide governments working with the customs brokers, with the importers, speak of checks and balances. The only check and balance you hear of is the Tax Appeal Board. But what of within the decision-making process at the Comptroller of Customs? So the Comptroller of Customs should be challenged by agency X or Y based on such criteria. The second major concern, Madam President, with the amendment to the Customs Act is regarding the ability of the Comptroller of Customs to detain and prevent further shipments of the importer. All right? This too should have a caveat outlining the reasons that the Comptroller must satisfy before he can so do. This then ensures justice can be done, as the powerless party in all of this will be the importer. This amendment, therefore, is wholly unjust, and it is unthinkable that it can sit here without these checks and balances, given these concerns outlined. Now, Madam President, I turn to the impact of this Customs Act amendment to business. Let's examine a regular scenario with importers and businessmen. Myself, a consultant for entrepreneurs. A businessman imports goods. He has his first shipment detained, and he has the other shipments on the way. He may have used financing, trade financing, to do so. All right? Now, most times it really is with the final container that this importer can see returns on his investment. All right, because he can repay the bank overdraft facility, he can pay the inventory loan, and he can pay his staff and generate profits. By preventing this businessman from the first container that he may not be able to pay for whatever reason, may mean the end of his business. Why do you tie the future containers to this first container? All right? Let this first container sit in the arbitration process and allow the businessman the other containers. All right? That to me is harsh and oppressive regarding the law. This amendment will definitely be a death knell for medium scale and small businesses, especially new entrepreneurs who decide to enter the business of distribution. Now, regarding the challenges that businessmen face in Trinidad and Tobago, I wish to highlight some points from two articles that would have been in the daily newspapers. Madam President, I beg to find out how much time I have remaining.
You have 14 more minutes.
14. Thank you very much, Madam President. And so the first article is from the Trinidad Guardian. All right. Efficient Customs Agency critical for trade. And this submission was by no other than Thomas Bermudez. I believe he would have been the outgoing IDB country representative for TNT, and Crystal Lucenti, IDB trade specialist. That would have been September 2nd, 2017. And Mr. Bermudez basically said that Trinidad and Tobago has untapped advantages in the maritime sector, both as a Southern Caribbean transshipment and logistics hub and as a special economic zone. But he said that corruption at customs, though is endemic across countries, is irrespective of their level of development. So he's not saying it's something that's unique to Trinidad and Tobago. But he said in Trinidad and Tobago, shippers and traders know that there is no consistency or transparency in the application of fees or charges, increasing the risk of rent-seeking behavior by agents. Rent-seeking behavior is a term common in the world of economics. It basically means you get paid for no work done. All right? So I would, in light of the article is very long, I can't deal with it in the time I have. However, I would like given that it comes from no other than the Inter-American Development Bank representative for Trinidad and Tobago, I think the government should really look at that when they vest all these powers, real powers in the hands of the Customs Authority. And another article in Trinidad and Tobago Guardian of Saturday, March 21st, 2015, Port and Customs blamed for high prices. And they said that inefficiency and additional costs on the Customs and Excise Division, they're blaming basically the operating costs of manufacturers also go up as we see business people have no choice but to pass them on to the consumer. So the inefficiencies, and based on the commentary by the IDB specialist, the rent-seeking behavior, all right, of the customs, the persons at the Customs Authority and the port, really and truly can have a deleterious effect. And when you vest the role of being a fair and unbiased body in an organization that has already been accused by none other than the Inter-American Development Bank country representative of rent-seeking behavior, and you're vesting this role under their care without sufficient checks and balances, they can basically decide which businesses will survive and which businesses will die in Trinidad and Tobago. Now, consultation with customs brokers. I turn to this aspect, Madam President. I submit today that this amendment to Clause 5 and Section 23 that ties up the future shipments was done without any consultation of any meaning with the members of the affected parties, the importers, the shipping agents, the freight forwarders, and the customs brokers. Now, this amendment flies in the face of good business practice and is a testament to the fact that there is no plan by this government for the industrial development and trade development under this Dr. Keith Rowley-led PNM. Now, I have, on behalf of these parties, the importers, the shipping agents, freight forwarders, and customs brokers, engaged them, Madam President, and asked their opinions regarding this particular amendment and solicited responses. And what they said was, the words that came from most of them was, it's unfair. I spoke to the president, the vice president, a senior broker, and a legacy broker whose family was in the business. And they said that dubious business practice may be encouraged, as a dummy company will probably now be created so that businessmen can carry on their activities. All right? So, and they say sometimes matters take an undue time to be cleared by the review committee. The president of the Customs Brokers and Clerks Association was livid when I spoke to him that such an amendment could even be conceived without first consulting with the association. He said that he felt betrayed because they are part of the Trade Facilitation Committee, Madam President. And for this amendment to be brought to Parliament, he said it's totally unjust, and he cannot believe. He doubted me until I sent him the details of the bill that would have already been debated in the House of Representatives. All right? So the Trade Facilitation Agreement came into force, I think he said it's in 2018 at the beginning of the year. And he said that this amendment is not supposed to happen like this. The Trade Facilitation Committee appointed by the government includes heads of various stakeholders in the country, and his name is Mr. Nicholas Rostand. So, Madam President, the other amendment regarding the 6 and 3 years, I think that was already dealt with significantly by members on this side, and members to come may also look at it. So I won't go there. But the last point I want to state on this Customs Act is that if you have to now advise a business that is entering Trinidad and Tobago, you have to now warn them that by virtue of the change in legislation, that the Comptroller of Customs, if he decides, can effectively stall your business to the point of which it may mean its end, especially given the fact that it is done so without consideration for your financing commitments for your products. Now, I turn to responding to some of the issues raised by the Honorable Attorney General and by members who went prior. Now, I want to look at the post-clearance audit aspects that was dealt with by the Attorney General. Now, post-clearance audit, I know the Attorney General only had 40 minutes, so he didn't have time to expound on what that meant and to explain that what it really means is a culture shift in the way we treat with assessment of value of imports and exports in Trinidad and Tobago, but particularly imports. All right, in Trinidad and Tobago, because that's where the state can be defrauded, or where persons can unknowingly avoid payment of taxes. All right. Now, Madam President, I read the source into the record. It's from the United Nations Economic Commission for Europe. All right. The post-clearance audit or audit-based controls are defined by the revised Kyoto Convention as measures by which the customs satisfy themselves as to the accuracy and authenticity of declarations through the examination of relevant books, records, business systems, and commercial data held by persons concerned. Now, administrations that do not use audit-based controls usually concentrate their controls entirely at the border and at the time of import, and often apply a 100% physical examination approach, which leads to unnecessarily long delays, and generally is not good for good business practice in Trinidad and Tobago. So therefore, a post-clearance audit is good news for business. However, the trouble lies within the details. And
Senator Obika, you have 5 more minutes.
Thank you very much, Madam President. And this really effectively is my last point, actually. So the post-clearance audit requires, and this is where the United Nations Economic Commission for Europe, all right, just for the Hansard, it's tfig.unec.org/contents/postclearanceaudits.htm. It requires an enabling environment such as a dedicated PCA organization within customs, PCA being post-clearance audit. The legal powers to access commercial records, which this legislation is trying to do, albeit the time of the records is an issue, and to enter traders' premises, properly trained staff, as well as the existence and proper application of accounting standards. So I wish this government can indicate what is the staffing component at the competent authorities, be it the Tax Appeal Board, be it the Comptroller of Customs, that will be charged with the responsibility of post-clearance audit. And if, in effect, that staff complement is not significant, Madam President, what you may rarely find is that they may be nitpicking and not necessarily taking a holistic approach to the system. And you may find that some traders and importers may find themselves being unfairly targeted because they may know of persons who may be doing things, and because there aren't sufficient numbers of staff in the competent authority, they can't be prosecuted or pursued. All right. So the World Customs Organization also has some points on a post-clearance audit. And I will end by just stating that if persons want to get more information, they can look at the guidelines for post-clearance audit, Volume 1 of the World Customs Organization, June 2012. Madam President, can I ask how much more time I have remaining?
3 more minutes.
Thank you very much. All right. So at this point, I really want to appeal to use the remaining time I have. I hope that the Attorney General would have been here so I could have asked this question. But I would defer it for persons to come after, then, since he's not in the room. All right, so basically, what I want to appeal to the government is, notwithstanding that they sit on that side and we on this, listen to the public. All right, the Customs Brokers and Clerks Association have stated that this is an unjust, although maybe for whatever reason they couldn't come out and say it openly. But we made a representation on their behalf, and this is an unjust change. They have been broad-sided and blindsided by it because it didn't come as a part of their deliberations in the Trade Facilitation Committee, and they should remove the amendment after consultation with all the stakeholders in the form of a joint select committee of the Parliament of Trinidad and Tobago. I thank you very much.
Senator Chote.
Thank you, Madam President. I don't know if I'm going to have 4 minutes or 40. 4? Well then, Madam President, perhaps I could just open by saying that many of the issues which I wanted to speak about have already been addressed by the other speakers, and very adequately so. So in my contribution today, I intend to look at 2 things. That is to say, the proposed amendment to the the Proceeds of Crime Act with respect to the issuing of a warrant and the impact of the warrant on the person being required to provide information. And secondly, with respect to the fines imposed under the Proceeds of Crime Act for matters which will now be dealt with summarily. So those are the 2 issues which I would like to address, and I don't know if I can urge your indulgence by asking that a break be taken, because it will be impossible for me to get off the ground on either of these.
Well, Senators, at this stage we will suspend, and because I'm feeling exceedingly generous, we will resume at 5 p.m. So we are suspended until 5 p.m.